Welcome to the module of the AMCTO HR Law program, which deals with accommodation. In particular, we're going to deal mainly with the accommodation of disability, which is only one of the 16 prohibited grounds of discrimination in the Human Rights Code, but is the one which produces most of the human rights and accommodation issues in the workplace. In many of the accommodation cases that you will deal with in your workplace, there will be no issue as to whether or not there is a disability, because the disability will be obvious, or the employee will have advised you that there is a disability and given you reasonable grounds to believe that he or she is correct. However, there are cases where there is a question, which is sometimes a legal question, as to whether or not there is a disability in play. If there is no such disability, the result is that there is no duty to accommodate. So it's important to understand what a disability actually consists of for the purposes of the code. The place to start in terms of determining whether or not there is a disability as defined by the code is the definition of that word in the code itself. As can be seen, that definition includes physical disabilities, developmental disabilities, learning disabilities, mental disorders or disabilities, and injuries for which benefits were claimed or received under WSIB. That last item is not typically relied on by itself as evidence of a disability, but rather is a factor which is taken into account in conjunction with some other circumstance which arguably gives rise to a disability. But the definition in the code is non-exhaustive, and because of the purpose of the code, the definition has been broadly interpreted and expanded by the courts and tribunals. And what those cases have said is that disability is not to be looked at or thought of as being a biomedical situation alone. In other words, it's not always something that is susceptible to being diagnosed medically. Rather, in considering whether or not a certain circumstance constitutes a disability, one has to look at the social political dimensions and the ability of the person to function in life, and particularly in the workplace, if it's workplace accommodation that is being sought. As we indicated earlier in the human rights section, the emphasis is always to be placed on human dignity, respect, and the right to equality. So in a case of workplace accommodation, it's really about what obstacles there are to the employee who has the disability or may have a disability to fully function, or at least successfully function, in the workplace. So we're going to look at a few situations and have you guess whether or not the condition on the slide is a disability. So if you click this slide once, you'll see the question, is this a disability, alcoholism, or substance abuse addictions? Before you click the slide a second time, give some thought to whether or not you think that is a disability. If you click the second time, you'll see that in fact it is. For some time, the courts and tribunals have treated such addictions as being the basis for a disability which is protected by the code. Tricky situations are when an employee gets charged or convicted with impaired driving on one occasion. That does not necessarily serve as valid evidence of a disability, but you need to investigate by interviewing the employee as to whether or not such disability actually exists. The next slide deals with head lice. In a case involving the York Region District School Board in 2010 at the Human Rights Tribunal, it was determined that head lice are in fact not a disability. The next slide deals with obesity. Obesity in and of itself is not a disability. However, if as a result of the obesity there is some limitation on the employee's ability to perform the activities of daily living or to work, that will typically produce a disability for the purposes of the code. The next slide deals with cold or upper respiratory illness. In a case involving Lily Cups, the company that makes the lids for styrofoam coffee cups, it was decided about 30 years ago that the common cold is in fact not a disability. Part of the rationale for that was that it would debase the important role that the code plays in protecting persons who do suffer from disability, from discrimination, to find that a common cold was a disability. The next slide asks whether asthma is a disability. The answer is a resounding maybe. Cases involving asthma have been very fact-sensitive and have generally turned on the degree of disability or impairment that is produced by the asthma condition. Many people have asthma and function successfully in the workplace without accommodation. This slide asks whether or not a perceived disability is entitled to the same protection as an actual disability. The answer is yes. There are a number of cases, including cases from the Supreme Court of Canada, that have held that a perceived disability is caught by the code or human rights legislation. In a case called Johnson versus D&B Traffic Control, Mr. Johnson was an overweight individual who functioned for some time successfully as a flag person on construction sites. When the work dried up, he was laid off. The next season, the work returned, but Mr. Johnson was not recalled. There was no basis upon which the employer could argue that his performance was unsatisfactory. The tribunal decided that one factor that affected the employer's decision to not recall Mr. Johnson was the employer's perception that his overweight condition would or could affect his job performance. Mr. Johnson was successful in establishing discrimination based on this perception. Now we turn to the employer's duty to inquire. The duty to accommodate is triggered when the employer actually knows or ought reasonably to have known of the existence of a disability. In other words, the employer cannot be willfully blind in terms of whether a disability exists. If there's a reasonable basis for the employer to suspect a disability, the employer has a duty to inquire and to engage in the accommodation process. Failure to do so can be costly and embarrassing. In the Krieger versus Toronto Police Services Board case decided in 2010 by the Human Rights Tribunal, it was found that the Toronto Police Service had failed in its duty to inquire. Constable Krieger was probationary with the Toronto Police Service. He was involved in a physical tussle during which the suspect pulled a gun and shot in the general direction of Constable Krieger. He was not struck, but the bullet whizzed by his ear. 5 weeks later, he was in a McDonald's in Yorkdale Shopping Centre in Toronto and observed an inebriated patron. He overreacted in his dealings with this patron. Within the few days after this second incident, he was exhibiting what could only be described as bizarre behavior. In fact, what had happened was that he had developed post-traumatic stress disorder after the first incident, which was compounded by the second. However, the supervisors dealing with Mr. Krieger's case dealt with him as a person likely guilty of professional misconduct, as opposed to a person who possibly was suffering from a mental disorder. After his suspension, Mr. Krieger sought professional help and was successfully treated for his disability. He tried to get the police service to consider the evidence from his physicians, but that evidence was treated with suspicion and derision. The service did not conduct any independent evaluation of Mr. Krieger's medical condition. Ultimately, Mr. Krieger was terminated by the Police Services Board. The result of the police service's willful blindness in this case was an order for $35,000 in damages to compensate Mr. Krieger for injury to his dignity, feelings, and self-respect, and an order for reinstatement, which, although available to the tribunal under the code, is very rarely exercised. Another difficult situation for employers is when the employee denies a disability, but there are reasonable grounds for the employer to suspect that such a disability actually exists. This is particularly the situation with suspected alcoholism, because one of the symptoms of alcoholism is in fact denial. All that an employer can do is to pursue a respectful process of inquiry, which may have to be repeated a number of times, to try to get to the bottom of it, and ideally to have the employee admit that he or she actually does suffer from a disability and requires accommodation. However, if that admission is not forthcoming, then the employer is entitled to deal with the employee in a disciplinary manner or other appropriate manner having regard to the circumstances. In a case involving Ontario Power Generation in 2006, the Arbitration Board held that the employer has a duty to take reasonable steps to ascertain the nature and extent of an employee's illness before either disciplining or discharging the employee. What is reasonable will usually depend on the particular circumstances. In a case involving Canada Safeway from Alberta, a grocery clerk started to demonstrate bizarre and unsettling behavior in the workplace. Rather than adopting a helping, supportive attitude, the employer adopted an aggressive, challenging attitude and ultimately terminated the employee. The Board of Arbitration ultimately held that the dismissal was unjustified, as the employer did not take sufficient steps to address the employee's denial of any disability and should have worked with the employee more. Next, we're going to talk about the case of Tawny Mioran. Tawny was a forest firefighter in BC, and as such, she would, as part of a crew, attack and suppress forest fires while they were small and easily contained. Her work was satisfactory, and there was no reason to question her continuing ability to do the work safely and effectively. Tawny had worked in this capacity for 3 years. At that point, the government decided to adopt a series of fitness tests for forest firefighters. A battery of tests was developed and administered, one of which was designed to test the firefighter aerobic fitness. The employees were required to run 2.5 kilometers in 11 minutes. Tawny's best time was 11 minutes and 50 seconds, and given that she failed the fitness test, she was laid off. A grievance was filed on her behalf by her union. Think about the following questions. Number 1, do you think that different standards should have been adopted for men and women? Number 2, do you think the test was a fair way of measuring a firefighter's ability to do the job? Number 3, if Tawny passed, even though her running time was below what was required, would that result in reverse discrimination for the men who couldn't pass the evaluation? The Mioran case went to the Supreme Court of Canada. The government argued that its aerobic standard was a bona fide occupational requirement, also referred to as a BFOR. It argued that it had, in good faith, implemented the fitness standard in order to ensure the safety of the forest firefighters and to ensure the integrity of the firefighting services provided by them. However, the government's arguments were shot down. The Supreme Court of Canada said that the aerobic standard that had been applied to Ms. Mioran was prima facie discriminatory and was not a BFOR. Ms. Mioran was reinstated to her position and compensated for lost wages and benefits. The Supreme Court of Canada adopted a 3-step test to assist in determining whether a particular standard or rule adopted by the employer was supportable. The first step is whether the employer adopted the standard for a purpose rationally connected to the performance of the job. This test is usually relatively easily satisfied by the employer. The second test inquires as to whether or not the employer adopted the standard or rule in question in an honest and good faith belief that it was necessary to the fulfillment of a legitimate work-related purpose. Once again, this test is usually easily satisfied by the employer. The third test inquires as to whether or not the standard or rule is reasonably necessary to the accomplishment of the legitimate work-related purpose. In order to show that, it must be shown that it is impossible to accommodate individual employees having the characteristics of the particular employee without imposing undue hardship upon the employer. In other words, the employee must be accommodated to the point of undue hardship. This is the most difficult prong of the three-prong test to satisfy. So the question becomes, what is undue hardship? The use of the word undue suggests that some hardship is going to be associated with the accommodation in question. The issue is, when does that hardship become undue? The Human Rights Code gives us some guidance as to the definition of undue hardship. Specifically, it sets out three factors that are to be used in assessing whether or not undue hardship exists. The first is cost, the second is external sources of funding, and the third is health and safety requirements. In terms of municipalities, it is very difficult to convince a tribunal, arbitrator, or court that an accommodation cannot be made because of cost. Wrongly or rightly, adjudicators over the years have assumed that public entities, municipalities, can raise funds simply by raising taxes, although that is probably not true, and is certainly not true in some circumstances. That appears to be the thinking. External sources of funding essentially involve government grants and the like. Health and safety requirements are, in my experience, the best place to put one's arguments. If you, as the employer, are trying to prove undue hardship, the health and safety factors are in relation to the public, co-workers, and to the worker himself or herself. Other factors relevant to the determination of undue hardship have crept into the case law, although they are not found in the code. What this means is that you might be able to convince an arbitrator to take other factors into account beyond the three mentioned in the code, but it will be very difficult to get the Human Rights Tribunal to look at these other factors. These other factors are things like business inconvenience and morale of other employees. There almost always is a morale problem if one or more employees are being accommodated in a work area and the other employees are resentful of the fact that they are getting off easy. Third-party preference can be a factor, as can the provisions of collective agreements. In the McGill University case decided by the Supreme Court of Canada, the court looked at the existence of a deemed termination clause which provided that an employee's employment would be terminated after 36 months if he or she had been absent for that period of time. Although the collective agreement provision was important, it was not the only factor that the Supreme Court of Canada found was relevant, and it also required evidence of accommodation having been thoroughly and properly addressed by the employer. Consider this situation involving Connie. What do you think the result of this case was on the undue hardship issue? Connie's termination was in fact upheld by the Supreme Court of Canada in the Hydro-Quebec case. Specifically, the court found that the employer had accommodated Connie to the point of undue hardship. The court stated as follows: the test is not whether it was impossible for the employer to accommodate the employee's characteristics. The employer does not have a duty to change working conditions in a fundamental way, but does have a duty, if it can do so without undue hardship, to arrange the employee's workplace or duties to enable the employee to do his or her work. A critical point to appreciate in the law of accommodation is that the duty to accommodate has two components: a procedural component and a substantive component. This was dealt with in the Mioran case and has been repeated in a myriad of cases from tribunals and the courts since then. The substantive component is the actual accommodation, the change in working hours, the workplace, the duties, whatever is necessary to properly accommodate the employee. The procedural requirement inquires as to what was done by the employer to investigate and consider options for the accommodation of the employee. What is required is a serious, thorough, and professional process to demonstrate that the accommodation of the employee or the lack of accommodation was the result of a considered and professional process. The Human Rights Tribunal of Ontario has found that the lack of such a process is in fact a breach of the Human Rights Code in and of itself, irrespective of what accommodation was ultimately put in place. The procedural duty has three main aspects. The first is the assessment of the situation and the gathering of relevant information, which in the average case involving accommodation of workplace disability will be medical information. The second is consultation and internal discussion in the organization. Once you have the medical information, you want to look around the organization to see what opportunities exist, if any, to accommodate the employee and his or her restrictions. And the third one is discussion, primarily with the employee requesting the accommodation and looking at his or her restrictions, but also her abilities and knowledge and that sort of thing. The point is that the employer needs to go through a thorough process in order to arrive at whatever the conclusion is. Yes, we can accommodate in this fashion, or no, we can't. In assessing the ability of the employer to accommodate the employee, one usually starts with the employee's own job, and one asks whether or not that can be modified in some way to allow the employee to return to it, albeit in a modified position. If that isn't possible, then the employer needs to look elsewhere in the organization. If there's a bargaining unit, one typically looks at other jobs in the bargaining unit and considers whether or not they can be made suitable. But whether there's a bargaining unit or not, the employer needs to look across the organization in its entirety. As a general rule, the employer is not required to create a position in order to accommodate an employee, and the employee is only able to claim such positions as are suitable and available. Turning to the substantive duty to accommodate, that requires the matching up of the employee's abilities and restrictions on one hand with the available positions or modified positions in the organization on the other. Sometimes consideration is given, usually on a short-term basis, to the bundling of tasks, which is dealt with on the next slide. Bundling of tasks involves the removal of certain tasks, often light-duty tasks, from other positions occupied by non-disabled employees, and providing those bundled tasks to the disabled employee as a means of accommodation. The objective of any accommodation is to provide meaningful work to the employee and to produce work that is of value to the employer. As to whether or not bundling of tasks is required as a means of accommodation, the law is unclear. Some arbitrators have required bundling of tasks, whereas others have not, on the basis that the bundling of tasks is tantamount to the creation of a new position, which, as previously stated, is not required. Other decision makers have gone down the middle and have required bundling of tasks as a short-term accommodation, but not over the long term. A recent case decided by the Human Rights Tribunal of Ontario called Venegas versus Liverton Hotels is instructive in that regard. Mr. Venegas was a banquet server and suffered a back injury. The result was that he could not lean or carry any weight of any significance. The essential duties and functions of his job involved preparation for banquets, service at the banquets, and teardown of the banquet, all of which required leaning and heavy lifting. The hotel employer accommodated the employee by allowing him to do ancillary tasks of other employees, such as folding of napkins, placing of cutlery, and the like. The employee ended up going on leave for other medical reasons, and when he tried to return, the employer would not permit him to return in that modified role, as there was no reasonable chance that his back would improve to a point where he could perform a regular job. That prompted the application to the Human Rights Tribunal. In dismissing the application, the tribunal said as follows: in order to provide the applicant with a job that was within his restrictions, the respondent hotel would have been required to create essentially a permanent assistant banquet server job in which the applicant would perform a fraction of the full duties of a regular banquet server. In my view, what requiring the respondent to provide the applicant with a permanent job comprised of the limited number of duties within his restrictions would entail is to require the respondent to add the applicant in an assistant role to the full complement of regular banquet servers they already required. This, in my view, would not constitute the applicant performing a useful or productive job in the context of the hotel's operation. Accordingly, I find that the duty to accommodate under the Code did not require the respondent to accommodate the applicant in this manner. Consider this situation involving Tim, who was a weekend bylaw enforcement officer, a member of the Mormon Church, and accordingly, Tim was unable to work on Sundays. He requested accommodation. What do you think the employer's obligations are? The question is whether Sunday work was a BFOR for his position. That would require the employer to go through a Mioran type analysis, which ends up at the accommodation to the point of undue hardship. We don't really have enough facts to know whether the employer could backfill Tim on Sunday or take other steps to accommodate him so that the result would be he would end up working only on Saturday. This case predated the Mioran case, but the arbitrator ended up upholding Tim's termination. But the same result might not be the case under a Mioran analysis. In conclusion, the duty to accommodate a disabled employee is an onerous one for the employer and requires the employer to undertake a proper and thorough process to investigate the employee's claim for accommodation. Any accommodation that is put in place on a temporary basis should be reviewed carefully in light of changing medical circumstances on the part of the employee and changing business circumstances on the part of the employer.